Now let's go to our next speaker, who will offer advice on navigating the legal nightmare of caregiving. Mr. D. Rep. DeLoach III practices estate planning, elder law, and probate at the law firm of DeLoach and Hofstra, PA, in Seminole. He is one of 100 attorneys who are board certified in elder law by the Florida Bar out of approximately 83,000 Florida attorneys. He is a member of the Life Care Planning Firm Association, the National Academy of Elder Law Attorneys, the Academy of Florida Elder Law Attorneys, Real Property and Probate section of the Florida Bar, and the Estate Planning and Elder Law section of the Clearwater Bar Association. Please welcome, ladies and gentlemen, Mr. Rep. DeLoach.
Welcome. Good morning. Good morning. It was about 10 minutes ago where I got the text that says, they're running a little bit early. I'm like, all right, I'll just head over here. And I literally just walked in the door, so need a minute to adjust. So let's see here. We've got the clicker, right? Excellent. So we're here to talk about navigating the caregiver's legal nightmare. And we know it's a legal nightmare. And in many respects, it's not just a legal nightmare, right? It's really, there's other nightmares that are going on. It's a family nightmare. It's a healthcare nightmare. It's a financial nightmare. And it's all going to dovetail in many different ways that we cannot expect. Just the difficulties. And the difficulties themselves are so many because most likely when you're being a caregiver and you're being a caregiver for a loved one, a family member, or a friend, is you've never done this before. You know, when you've never done this before, it's typically very, very difficult. And what I always say is, and when we're talking with families who are going through difficult situations and they're starting to get into the legal nightmare, is ultimately is you don't know what you don't know. And when you don't know what you don't know, you can't ask the right questions. And when you cannot ask the right questions, you certainly can't get the right answers. And so what we're going to talk about today is some of the things that you probably don't know, some of the things that you may hear, some of the things that you may hear from people who have good intentions, but actually don't even know what's going on. And when you find when you're out there, when you're dealing with caregivers, when you're dealing with financial planners, when you're dealing with bankers, when you're dealing with the nursing home or dealing with the assisted living facility or doctors, you name it, is many people will very much have great intentions, but they can also give terrible advice. And the terrible advice will just come about in different ways that you may see, but ultimately, we think about navigating this portion of it, some things that maybe dispel a few myths or rumors, and just as ultimately is a way of helping you learn things that you don't know. And that's my goal here today, of navigating the caregiver's legal nightmare. And the topics we're going to discuss is our common scenario, as a common scenario of what we see on a daily basis as an elder law attorney and as a life care planning law firm, the things that we see, because we know what many of you are going through. And it's also going to be discuss how we see and how we view the lens of being a caregiver because of the things that you've probably gone through or you may be going through one day. We're going to talk about durable powers of attorney. We're going to talk about advanced directives, and later on there's going to be another speaker who's also going to talk about advanced directives. Then also there's going to be paying for long-term care. So all the different dovetails of the different things that you may or may not be going through that you could go through someday, but ultimately it's a matter of the things that you could be going through, but dealing with powers of attorney, healthcare surrogates, living wills, and then obviously it's really how do you pay for long-term care, because paying for long-term care can be very expensive if you haven't figured that out already. So we'll talk about that and just take our time. So the really thing to think about is our common scenario. Our common scenario is a frantic phone call, typically from a daughter. And the daughter basically it says this, is that my mom, she's 85 years old, she has just fallen and she has just broken a hip. And the daughter is in a very difficult situation. She's never done this before, and she doesn't really know what's going to happen next. And mom has been in this situation, mom has been discharged from the hospital, and she's gone to rehabilitation in the skilled nursing facility, the rehab center. And then ultimately, even before mom fell and broke her hip, mom's health and mental picture had already been declining. So some of you may have already been experiencing something like this, but mom's kind of been going downhill. She's been slowing down. She's had some dementia, which is getting in the way of things. And she's fallen now, and she's broken her hip. And what we know is this is 60% of all entrances into the skilled nursing facility is through a fall. I mean, it's just such a large percentage of all people going into getting the skilled nursing. It's a fall and break a hip, or they break a hip and fall, or even worse. I mean, there are worse falls than that. But ultimately, this is part of the entering the legal nightmare. And when we think about what questions that the daughter's going to have, the daughter's the caregiver, the daughter may be the power of attorney or may not be the power of attorney. But ultimately, the daughter's going to have a lot of questions. And so what are these questions going to be? These questions are going to be am I power of attorney? Am I healthcare surrogate? Can I make my mom's healthcare decisions? What about her living will? What about Medicare? Wait a minute, she's in the skilled nursing facility. How's that going to be paid for? So what about Medicare? Or does mom have a Medigap policy? Does she have an HMO? How long is she going to stay in the skilled nursing facility to get rehabilitation? What about the care that mom is receiving in the skilled nursing facility? What happens, is mom going to be able to go home after she gets stronger from the rehabilitation? Is she going to be able to go home, or can she go to assisted living? What happens if she has to stay in long-term care? How do we pay for it? What about Medicaid? What about VA benefits? What about her will? What about her trust? All these different things that the families typically have never gone through before. And you're typically thrust into this scenario. What we typically would think is that mom, she did not want to leave her home, right? She wanted to stay at that home for as long as she possibly could, typically. And then the daughter said, I want to make sure my mom stays at home for as long as she possibly can. And mom didn't really want to leave home anyway. So the daughter did not want to push her out the door to try to get her into an assisted living facility maybe. But ultimately, this is kind of thrust upon the situation due to the fall, the hip fracture, and now mom is in the skilled nursing facility getting rehab. And I say this is all part of the caregiver's legal nightmare. So part of the legal nightmare is what do we do next, and what are the things that should be considered as far as preparing for this legal nightmare, and if this hasn't already been done, then what should be done, and what are things that we all need to think about when we're going through this legal nightmare together. The first thing we think about is by far the most important thing that we really could be considering is creating the durable power of attorney. Last year at this seminar, I gave a talk on for an hour just on powers of attorney, healthcare surrogates, and living wills, but even just really powers of attorney. So we know that the depth of the conversation of the power of attorney is so very, very important. But a power of attorney, simply put, is the power to make someone's legal and financial decisions on someone else's behalf. It is the most important document, and arguably the most important document that anyone could create when they're trying to deal with their caregiver, trying to care for their loved one, because the power of attorney itself, we always say this, is really it's going to be worth its weight in gold. Because we don't necessarily know how helpful the power of attorney is going to be, but we just know if you need it, it's just so very, very helpful. So creating a power of attorney itself is just part of preparing for the future. And as soon as the power of attorney is created, it is effective. So as soon as the power of attorney is signed by mom or dad or what have you, then it's effective at that certain time. So sometimes people say, well, I don't want to give up my powers. I don't want to give up my rights to my daughter. And sometimes people say, I'll sign the power of attorney when I need to sign the power of attorney. And we hear a few chuckles, right? And people put it off. And now I'll sign it when I need to sign it. But ultimately, the power of attorney is effective when it's signed. And we hope that, we never use a power of attorney. We hope we all live a long, healthy life, and maybe we don't wake up one morning, right? But ultimately, the power of attorney itself is so very important, and as soon as you sign it, it is effective. It was a few years ago that Florida statutes put into effect what's called a springing power of attorney. And a springing power of attorney, it sprung into effect when mom or dad became incapacitated. But those were basically taken out of the statutes in 2011. So basically, you create a power of attorney, it's presently active as soon as signed, so you don't need to get letters from doctors, letters from saying that mom is now incapacitated. And we see that on a daily basis, that the daughter went down to the bank to register the power of attorney, and the bank says, we need to get letters of incapacity that mom is incapacitated. And they say, well, the power of attorney is effective as soon as it's signed. So the bank doesn't know what they're talking about. We see that on a daily basis. They're going to give the powers of attorney, who are generally referred to as the attorneys of fact, they're going to give them a lot of trouble. But as soon as you sign a power of attorney, it's going to be effective. And that means the daughter can go out and help mom or dad in various effects, especially as their mental abilities are declining. One of the most important things that a power of attorney can do is it can help avoid a guardianship. And a guardianship self, we've talked about how the difficulties that we go through, and some of you may have experienced the guardianship process. If you're dealing with someone that has declining capacity and they may be taken advantage of by other people, or they may be wandering the streets, they may not be compliant in their health care directives, sometimes you have to seek a guardianship. But mostly when you create a good, durable power of attorney, you never really need to create a guardianships for the most part. The power of attorney itself is a delegation of your legal rights and your financial rights, but it doesn't take your rights away. So sometimes we've had people say, well, I'm power of attorney, I can make mom's decisions. Well, ultimately, it's up to mom. It's going to be mom's decisions, and even if she has capacity, or even if she does not have capacity, the power of attorney is not going to overrule mom's decisions. But what we may see, a very common pattern, is that eventually people kind of give up their roles and gives up their ability to sign their bills or pay their bills or what have you, and that's when the power of attorney can more effectively take over. So you create a power of attorney with the hope that you avoid the guardianship procedure, at least in most respects. And we know that guardianships are not avoided all the time, but a good power of attorney is fairly effective, very effective, in avoiding the guardianship itself. Because a guardianship is going to court, it's a court process, a bunch of attorneys are involved, it's fairly expensive, it's fairly time consuming. Maria is an expert in these areas. And then ultimately, it's just not a very good way to manage someone's affairs. While having a good, durable power of attorney is very important, generally you can avoid that for the most part. What we do say about durable powers of attorney is get an attorney to get one. Go to an attorney to get a durable power of attorney. And actually, I really should change the slide. I'd say not go to an attorney to get one. I'd say go to a good attorney. and not just go to a good attorney. What I'd really say is go to a good elder law attorney. And that's not trying to be self-serving, but I had a client come in last week, and they went to an attorney to get a power of attorney for mom. And the power of attorney was less than 6 months old. And this attorney obviously was not on top of their game. The power of attorney statute changed in 2011, October of 2011, and this attorney had not updated the power of attorney form since October of 2011. So they haven't updated their form in over 7 years, and you're going to tell me this is a good attorney, and it's not. So it's not just don't download the form online. Do not get it from the nursing home that says, oh, here's a power of attorney form, because you will not be able to rely on that later on. So it's go to not just an attorney, go to a good attorney, not even go to a good attorney, go to a good elder law attorney. And we're going to talk about why you need to do that, but ultimately you just have to have the best form possible because it's going to be worth its weight in gold. So how can a power of attorney help? Power of attorney can help in just so many ways, and these ways are not necessarily we're able to predict all the wonderful ways that a great, durable power of attorney would be helpful. It's the power to sell home, and it's the power to pay bills. And we've had people say, well, I don't need a power of attorney. I'm on all of mom's bank accounts. I'm on all mom's bank accounts. I can pay her bills, but a power of attorney is much broader than that. We don't even know all the effects of what it could do, but ultimately it's more than just paying bills. It's helping protect assets. We're going to talk about a little bit about asset protection later on, Medicaid and VA benefits, but these are very important things that a good power of attorney can help protect the assets from the nursing home. It can help make mom's assets last longer so she can get better care. It can help avoid probate for heirs. So if we had an informal poll of the audience, if you want your assets to go through probate when you die, I don't think we'd have many people raise their hand. But a good, durable power of attorney can help the family avoid probate upon mom's passing. There's the power to create trust, the power to create special deeds that can be contained in a good, durable power of attorney. In a bad power of attorney, you can't do any of these different things. So that's why you go to a good attorney to do that. To help bring a good estate plan together. The power to create trust that can be contained in a good, durable power of attorney is a power to help eliminate probate, bring the estate plan together. Again, it's just so many things that can be done as long as you have a good power of attorney. So I say much, much more. We don't know all the great things a power of attorney can do. The power to protect assets, the power to protect mom, it's the power to set up trust. You name it, it's just such a great thing. So go to a good attorney to do that if I haven't said that already. The advanced directive, so we're thinking about is in this nightmare scenario where mom has fallen and she's now in the skilled nursing facility, then we think about, besides the power of attorney, we're thinking about the advanced directives. And the advanced directives is going to be your living will, the designation of healthcare surrogate, and the do not resuscitate order. So with the living will itself, it's of course going to be a matter of writing down and letting your family know what your end-of-life wishes will be. There's going to be another speaker who's going to talk a lot more about living wills, but we'll just in general, we'll go into detail a little bit. The designation of healthcare surrogate is a great, great thing, and then the do not resuscitate order will go into the detail, but these are called advanced directives, and these are all part of preparing for your incapacity for the future. As part of the living wills, a living will is very important. A living will is important in many respects. So what is a living will? Of course, a living will is a written or oral statement as to your end-of-life wishes. So we always generally say is that you should place your living will in writing, that you would get a good form and place a living will in writing. But ultimately, sometimes people don't want to place them in writing. Say, I trust my daughter, my son will make my health care decisions the right way at the end of life. So a living will is not just what you have on paper, what you have set pen to paper, but it's also an oral statement as well. So if you say, son, don't ever keep me alive if I'm in a vegetative state or something like that, that's also a living will. We'd generally rather it be in writing, but just the past couple of weeks I had a few of my clients, they say, you know what? I trust my daughter, and I don't want to place my wishes in writing because she knows what my wishes are. Okay, well, that is a living will as well. We generally, again, we'd like to have it in writing, but if sometimes people don't want to place it in writing, we're not going to, make them do it, of course. It's their wishes, and a living will can be an oral statement as well. So how to create one, again, it's you, basically a living will is going to be signed in the presence of two witnesses. If you do place it in writing, that's the best way to do it, and what to do with it. And what to do with it is very important, but what you do is you share it with your healthcare surrogate in the first place. We know there are probably times in this, people in this room may have done this, where they've been named as a healthcare surrogate, and sometimes they didn't even know they were named as the surrogate. So mom's fallen, she's broken the hip, well, who's the one that's making mom's decisions? Oh, well, I guess I am. We know that that's happened on multiple occasions, so what you do with your advanced directives is you share it with your family. You share it with your doctor, and then hopefully they would be able to spread it around at the right time regarding making end-of-life decisions. Making your living will is effective. Really, what they say is the study after study will say is a living will itself is most effective when you've talked with your healthcare surrogate about your end-of-life wishes. So you can have a great living will that says exactly what you want at the end of life, whether you'd like to have resuscitation, or whether you want to have antibiotics at the end of life, or whether you'd want to be, be on a feeding tube, or anything just to that effect. But the best thing that you can do is talk with your surrogate about what your wishes are. So what we always say is just, it's not necessarily about what's in writing. That's very, very important, but it's even beyond that, because you've let your family know what your end-of-life wishes are. There's going to be a lot about the conversational aspects of living wills later on, but we think about talking with your surrogate. Where would you want to receive care? And I think most people would say that they would not want to receive care in a nursing home, of course, but there is a matter of could you ever move from your home, could you be happy in an assisted living facility? And assisted living facilities can be really great care, but there's spiritual aspects. Do you have any spiritual aspects that you want to know? And what could that be communicated to the family? Things that, these are very personal and deep issues, things that you'd want to share. What have they seen in their life? Many people have dealt with end-of-life wishes with their family members already, where my husband died of cancer, or my mom, went through a terrible end-of-life states. And your life experiences, you can share that with your family members as to who, part of what your wishes are. So it's not just, again, putting it down on paper, but it's sharing your life experiences and how has that made your opinions form. I had a client who was in a couple of weeks ago, and her husband died after a long bout of cancer for his 2 years, a bout with cancer. And what she knew is, she said, whatever he went through, I do not want to go through. And so having that down on paper would be important, but it's also really, it's about sharing what you'd want with your family. Make sure everyone has copies and have a good living will. Our office, we use a variation of the form of the Empath Choices for Care living will, and Tracy Christner is going to be talking about Empath Choices for Care and the living will specifically, but these are the ones that I fully endorse, partly because I helped draft it, but ultimately it's an amazing document. The designation of healthcare surrogate is who would make your healthcare decisions. And I used to say, I always really kind of say, who would make your healthcare decisions if you're not able to make those decisions yourself? But that's not necessarily the case anymore. The healthcare surrogate used to be what we'd generally refer to as a springing healthcare surrogate. The healthcare surrogate only would go into effect when you became incapacitated, and you generally needed a doctor or 2 doctors to declare that you were incapacitated. But the law was updated in 2015 in September, and actually, the legislature did something great, is they changed the law. And they said the healthcare surrogate itself is not going to be a springing healthcare surrogate. It says that if you initial next to a couple of areas, then the healthcare surrogate could be effective as soon as it's signed. And the way it used to happen would be is this. In our nightmare scenario, mom has fallen and she's broken her hip, she's gone to the doctor, she's gone to the hospital, and then the daughter goes up to the doctor and says, hey, I'm the healthcare surrogate, what's going on with mom? And the doctor says, well, you're not the healthcare surrogate. And the daughter goes, no, I'm the healthcare surrogate, it's right here on paper. And the doctor says, yes, but your mom's not been declared incompetent yet, so therefore the healthcare surrogate is not in effect, so therefore I can't talk with you. So what they did is they did the update of the statute, said if you initial next to one area, then your healthcare surrogate that you nominate can now talk with your doctor. So you don't have to have that formal declaration of incapacity. So it's just a great little update. The next thing they did is they said, you know what, you can initial next to another area. It says you don't even have to be declared incompetent in order for your healthcare surrogate to make your decisions. What we know about dementia, especially the people in this room have probably experienced, is dementia itself is a slow decline, or typically it's a slow decline, where sometimes you're going to be competent, sometimes you may be incompetent, sometimes you may be good in the morning, sometimes you may not be competent in the evening with sundowning. So ultimately it can be a long decline, and you can sign a document that says, I don't care if I have been declared incompetent by 2 doctors or not, I just trust that my daughter is going to make the right decisions for me. Sometimes, for instance, that medical decisions can be very complex. A mom may be competent to make certain decisions about her own health care, but what about getting cancer treatments at the end of life, or getting radiation therapy or chemotherapy? Maybe mom would not have the capacity to make these very complex decisions. So the designation of healthcare surrogate had a great update in 2015, and it can be presently active, which is a wonderful thing. What we generally say is we do not do co-agents on our designations of healthcare surrogate. We'd hate for people to disagree at end of life. So when you're making your healthcare surrogate, choose the right person and then just name alternates. If your daughter can't do it, then name your son, then you name your other son, then you name your grandson. Keep on going down the list if you need to, but ultimately we do not do co-agents because we do not want your surrogates to disagree on end-of-life wishes, on removing life support, for instance. We don't want to do that. And then the revocation of healthcare surrogate itself, ultimately healthcare surrogates can be revoked. It's best to do it in writing, but frankly, you can do it in an oral statement as well. Say, I revoke my healthcare surrogate. And we hope that that never occurs, at least in the wrong way. Next is the do not resuscitation order. So a living will is an oral or written statement as to your end of life wishes, but the do not resuscitation order itself is an order from a doctor. And it's going to be a yellow paper signed by a physician. So this is not going to be an attorney document. You know, power of attorney is the attorney document. We generally think your living will and healthcare surrogate should be done by a good attorney as well, but there are other alternatives. But the do not resuscitation order itself is not by an attorney. It's going to be issued from the doctor, and it's going to be on yellow paper. And it's not a living will, of course. A living will is a written statement or oral statement that you would maybe want to have a do not resuscitation order. But the living will itself is not a DNRO. And you know, from the biggest thing is the general effectiveness of CPR. And I know this is a big thing of mine, and we think about, you know, living our lives and try to live a nice, healthy life, but ultimately we know this about CPR itself. And I've had clients that are they're doing terrible, and then they're in the nursing home or they're in the hospital, yet they do not have a do not resuscitation order. We know that they're at the end of their life, and if you have a heart attack, and that can be a peaceful way to go. But sometimes people refuse to do DNRs, or they didn't talk with their doctor about them. But ultimately, this is a very sobering fact, is that a healthy person who receives CPR has a less than 15% chance of full recovery. So statistically speaking, the chance of a very healthy person getting CPR and fully recovering is actually very slim. And for someone that is of older age, that someone has multiple health issues, the chance of full recovery is less than 2% statistically. So having a do not resuscitate order is so very, very important, especially as someone is going downhill, declining with dementia, has a low quality of life. You know, they've talked about it with their family, but having a DNRO is so very, very important in so many respects. Because the receiving resuscitation at the end of life can do so much damage to your body. It can break your ribs, cause internal bleeding, and they generally immediately put you on, you're intubated after that, and you're going to be put in a medically induced coma, just all kinds of fun things that can be avoided if you've communicated with your healthcare surrogate, and then your healthcare surrogate knows at the right time to create the do not resuscitation order. And again, the living will is not a do not resuscitation order. No one cares if if you had a living will that says do not want to be resuscitated. No one cares about what that says without the doctor's order itself on yellow paper, which better be the hospital file, the assisted living file, place it on the refrigerator, give it to the nursing home. These things are very, very important, and they do not travel well, so make sure you do them wherever the elder is living. Next is part of it, when we think about preparing for, so you're prepared for your incapacity with your durable power of attorney and your designation of healthcare surrogate, your advanced directives. So what about this? What about paying for long-term care? So this is very much part of the legal nightmare because there's just so many aspects to figure out how to pay for it. Again, we've got Medicare, we've got VA, we've got Medicaid, all the different aspects to this. What we know is paying for long-term care is expensive. And how long is someone's money going to last when they need care? So we'll spend some time talking about the various programs or various ways to pay for this. This is part of the great, great difficulty. And I say it's difficult because it's difficult for me as an elder law attorney. As I know the rules for these programs backwards and forwards, but it doesn't mean it's going to be easy for any of the family members to go in through it, much less myself, my staff, because there's no such thing as an easy VA application. There's no such thing as an easy Medicaid application. That's also very difficult. What we know is long-term care is expensive. If you had a home health care company and the home health care company charged $22 an hour, which is kind of about the going rate, and $22 an hour, if you did that, if mom could stay at home and you say, I want to keep mom at home for her entire life. All right, then if you needed 24-hour care at $22 an hour, 7 days a week, 365 days a year, that's over $180,000 a year. So we know staying at home can be very, very difficult. And many of the caregivers try to do this, but we know it's just difficult. Where sometimes assisted living facilities can be a great place to receive care. So if you can't keep someone at home, if we're dealing with someone that's dementia, someone that has dementia, someone that's exit seeking, someone that can be very difficult, maybe keeping them home just is not the best option, not even from a monetary standpoint. Glenn Campbell, who maybe saw his widow speak, she put him in an assisted living facility in order to receive care. Money was not an issue for them, but she still decided that she wanted to place him to an assisted living facility just through the various care angles. But in an assisted living facility, you may know this, but there are different levels of assisted living. We generally say assisted living costs anywhere between $2,000 to $6,000 per month. It can even be a little bit more expensive than that, but kind of from a range, just a ballpark range, mostly from $2,000 to $6,000 per month. And this is not going to be secured dementia unit. It's going to be quote-unquote regular assisted living. Where a secured dementia unit, such as Arden Courts, for instance, there's the dementia assisted living facility that's generally from $3,000 to $7,000 per month. So we know care is going to be very, very expensive, and especially if we get to the end with the nursing home. So the nursing home is what we refer to as the most restrictive environment. All of us in our lifetime, we want to live as independently as we possibly can for as long as we can. And most of us would say we'd never ever want to end up in a nursing home. But if we did have to end up in the nursing home, that's obviously where it's going to be the most expensive. It's the most confining environment, but it also has the most medical care available. And that's where it's also going to be most expensive, of course, ranging from about $8,000 to $11,000 per month in the area. So you can shop around if you can see there are some differences between them. So if we think about, and our nightmare scenario where mom fell and she's in the skilled nursing facility, one of the first things that people start thinking about in paying for long-term care, okay, mom's in the skilled nursing facility, how long is her health insurance going to pay for that? So we'll talk about long-term care and Medicare. So what about Medicare? How's Medicare going to be helpful to pay for mom's stay in the skilled nursing facility? And of course, the rehabilitation facility, mom fell and she broke her hip. So rehab is going to be there to get her stronger. And typically, we're going to have two choices to pay for her long-term care. The choices to pay for her long-term care are going to be for whether she has Medicare or whether she has an HMO, basically going to be a Part C plan, which is going to be a Medicare replacement. But the options there is Medicare is going to be help paying for this in some respects, but Medicare, it does not pay for long-term care. So sometimes people say, well, what's Medicare going to pay for? And I had a lady that called, that came in yesterday, and she said, well, I want to have a caretaker come in and clean my house and make sure I can stay home longer and cook me meals. And said, will the government pay for that? And the basic answer was no. So sometimes people think that Medicare is going to pay for things, but Medicare is really a health insurance program. It's not a long-term care insurance program. And health insurance, the whole idea is to get you stronger. And so mom fell, she broke her hip, and she is now in the skilled nursing facility. And what this will say is mom has up to 100 days of rehab after a 3-day hospital stay. So in this typical scenario, mom did fall and she had a decline in health. Everyone generally knows that, hey, mom better stay in the hospital for 3 days. And once she stays in the hospital for 3 24-hour periods, basically it's 3 nights, then she could leave the hospital and then go to the skilled nursing facility. And Medicare will pay for up to 100 days of rehabilitation in order to get stronger. And this is part of the health insurance aspect to it. It's to get you stronger. And so that after the first 20 days of Medicare, then there's going to be a copay. The copays are the days 21 through 100, and the copays are around $167 per day. Now, if you have a Medigap plan, most of the Medigap plans will pay for that $167 per day. So Medicare pays for 100% days 1 through 20. After day 20, then the cost is $167 per day unless you have a Medigap plan. And the Medigap plan may pay for it. Not all of them do, but some of them pay for that $167 a day copay. So will mom or dad get the 100 days? I mean, we know this, so sometimes people, when mom or dad experience this downturn in health, and they went to the nursing home, and the nursing home staff said, okay, well, they got 100 days. And people go, okay, great, it's 100 days. I know at the end of the 100th day, we'll make plans to figure out what's going on. But the great reality is that most people do not get 100 days of long-term care. So they're expecting to get 100 days, but it's very rare. We'd say less than 5% of my clients that come in actually get 100 days in long-term care. It's just such a rarity, because what happens is Medicare and rehab is there to get you stronger. And when it's there to get you stronger, there's a point where you're not going to get any stronger, or rehab is not going to be any help. It's not going to help you get any stronger. So Medicare is generally going to end, and it generally ends well before the 100th day. That can be very shocking, and can only give a 2-day notice in order to end. And then all of a sudden the family is this is really part of really entering the legal nightmare now, because we have to figure out what's going to happen next. So Medicare is very ineffective. Medicare really just doesn't pay for long-term care. So what's going to happen when Medicare ends? And also, we will mention this, is if you have an HMO, the HMO rule is going to be fairly similar, but they're not going to be as good. We do know this, is Medicare is a much better way. If you're dealing with mom who's in declining health, having Medicare is a generally much better way than having an HMO, because an HMO will try to get mom out of rehab much sooner than Medicare will. As a general tip. So what happens after Medicare or the rehabilitation ends? Then we have to figure out, now we're in the long-term care world. And we're in the long-term care world is so mom's fallen, she's broken her hip, now what's going to happen? So is mom going to be able to go home? Will mom go to an assisted living facility? Will mom go to a dementia care assisted living facility? Or will mom need to stay in the long-term care facility, basically what we generally refer to as the nursing home? Will mom have to stay in the nursing home? We kind of have this gambit of options that have. People start freaking out at this point in time. Of course, Medicare is going to end, and we don't know what's going to happen with mom. And when it's going to get very expensive, and the family doesn't know what's going to do. But the options are, again, is go home, go to an assisted living facility, go to a dementia care facility, or or stay in a nursing home, or go to a different nursing home and pay for long-term care. So generally there's 4 ways that we figure out how to pay for long-term care. Self-pay, veterans benefits, Medicaid, and a combination of these. And so the first thing we think about is self-pay. So how do you pay for long-term care? Self-pay, okay, there's different ways to self-pay. It helps to have a lot of money, right? So if that's an option, the reality is Medicaid or VA benefits may or may not be helpful. It was a couple months ago, I had a family member that came in, and mom was in the nursing home. And what they knew was this, is that they knew a lot of people were in the facility getting care, and they knew that basically part of our long-term care system is so many of the people that are in the nursing home are on Medicaid. It's such a large percentage of our society that goes on to Medicaid when they're in the nursing home. And this family says, well, I want to figure out how to get my mom on Medicaid. All right, what are your assets? And they said, well, mom's assets are a little over $4 million. And I said, gosh, I'd really like to help you out. But they were the proverbial self-pay. And you don't need $4 million in order to self-pay. And it's going to, there's lots of factors to how to figure it out. But I got to break it to them that they had, if $4 million earned 2% a year, that's $80,000 a year just to pay for long-term care. We're not even touching principal. So she could pay for it. If I have 5 minutes, I could stretch it out, 10, 15, barking. So anyway, self-pay is an option, and we'll keep on moving. VA benefits, veterans benefits itself, there's lots to be said about veterans benefits. You could go to a 2-day conference on just veterans benefits alone. But ultimately, what we think about this is that if you're looking to pay for long-term care, there are VA benefits that are available. And the VA benefits are generally going to be part of the pension side of things for the most part. So most veterans, when they came back from the war, or if they were experiencing a wartime, most of the veterans did not access any VA benefits that they could or would have, except for the ones that had a disability that came from their time in the service. Most of them just came home from the war, or came home from things, and they just went on with their lives. But now that if they did fight, or if they did serve in a wartime, they didn't actually have any active duty or active wartime or anything like that. They didn't have to be in the location. They didn't have to be in Japan or they have to be in Korea or what have you. But if there was served an active duty during a time of war, and the time of war, of course, are generally going to be World War II, Korea, and the Vietnam conflict, the ones that we're experiencing now, then there's the possibility for VA benefits. And these VA benefits can be very helpful in the right situation. And what it can provide is these costs that help pay for long-term care, a little over $2,100 a month for a married couple, $1,800 a month for a single veteran, and then $1,100 a month and change for the surviving spouse of a wartime veteran. It can be very helpful. But it's ultimately based upon unreimbursed medical expenses. So it's not going to be for everyone, but it's going to be a couple of situations where unreimbursed medical expenses, and that's probably going to be where mom or dad needs long-term care. So it's going to be in-home care or assisted living. The VA benefits and the VA benefits program, just generally, most people refer to this as aid and attendance, but it's VA pension benefits is the more proper term, but it can help out with your unreimbursed medical expenses. So there's a lot to be said about it, but it's basically you have to have assets in a certain level because there's asset limits as well. So if mom has $1 million or $500,000, maybe accessing VA benefits would not be advisable or possible, but ultimately if you have unreimbursed medical expenses, then the VA can be very helpful. We do say this, it's very helpful for in-home care or assisted living care. It's not really helpful for the nursing home so much, and the big reason why is the nursing home is just so darn expensive. If the nursing home is $10,000 a month and you can get mom $1,100 a month to help pay for that for the VA, that's generally not going to be very helpful because mom's money is going to probably disappear very quickly. Medicaid and long-term care. Medicaid is helpful to pay for long-term care if you reach certain income and asset levels. We'll say this, is that Medicaid is really, it doesn't differentiate between who's receiving Medicaid or who's not. So if your mom's in a long-term care facility, the facility is going to provide good care for mom, whether she's on private pay or whether she's on Medicaid. The caregivers do not care, and it's actually illegal for them to discriminate against someone based upon their payer source. So you're going to get good care while on Medicaid. And it's great for the nursing home care as well. So what we generally say is Medicaid is really great to help pay for nursing home care because it's so darn expensive, but it's not so great for assisted living facility. You can get Medicaid and you can get VA benefits to pay for assisted living, but assisted living, it only provides about $1,100 a month subsidy. But there's a long wait list to get on that as well. If your mom is in assisted living facility or she's entering the long-term care, it's a good opportunity to look at getting Medicaid to help pay for the benefits. But ultimately, assisted living is very difficult. So what we know is this, is that experiencing dementia and then getting government help to pay for long-term care in an assisted living facility or in a dementia care facility, that's the most difficult thing to get because the government's not really that helpful. I mean, it's somewhat helpful to pay for assisted living care, but again, it only provides about $1,100 a month subsidy, and even getting that subsidy is not very good, not very easy. So if you're going to a $5,000 or $6,000 a month dementia care facility, the $1,100 a month doesn't go very, very far in most circumstances. I'll say this, assets in Medicaid, there's a countable asset limit, $123,000 in countable assets for a couple, only $2,000 for a single person. The countable assets include bank accounts, stocks, bonds, mutual funds, basically anything that you own. And sometimes people say, well, I'm on mom's bank accounts, and does that mean that half the money is mom's and half the money is mine? And the basic answer is no, it's all going to be considered mom's money. So countable assets basically include just about anything that you own. And the assets excluded from Medicaid is a home of up to $572,000, one car, and burial accounts. So this is the basic thing. In order to get Medicaid to help pay for long-term care, then you need to fall within their very strict asset guidelines. What I say is this, is, sometimes people say the nursing home is going to take mom's money. And the nursing home will never take mom's money. The nursing home is just going to expect to get paid until mom is otherwise eligible for Medicaid. Income in Medicaid, very briefly, your income cannot exceed $2,250 per month, but that's why you have a great durable power of attorney in order for a way around that. IRAs are considered income for Medicaid purposes. They're not going to be considered assets. So that's if mom has $300,000 in IRAs, that could be countable as income for Medicaid purposes. That may not be countable as an asset for Medicaid purposes, very importantly. And when you're in the nursing home, basically all of your income goes to the nursing home, and you're allowed to keep $105 per month. That's going to be changed to $130 per month. So a single person in the nursing home, again, is all of their income goes to the facility. They're allowed to keep a little bit of money for themselves as part of the patient's responsibility. And then the spousal rules itself is mom at home, if there's a spouse at home, the spouse at home may be able to divert some of the spouses and the nursing home's income as well in order to maintain a minimum standard of living. But the spouse at home is also allowed to have unlimited income as well. So there's a lot to be said about the spousal rules. Where am I on time? That's it, huh? Don't give your money away to get on Medicaid. Please do not go see an elder law attorney.
Where's the mic?
Could you tell me, is a power of attorney from New Jersey, would that still be good here as well? Because my husband has dementia and he has declined somewhat and he wasn't at that time.
So the question again is the power of attorney from New Jersey good? The basic answer is yes with a but. When the Florida statutes were changed in 2011, the rule specifically said that out-of-state powers of attorney, if it was good in New Jersey, then it's going to be good in the state of Florida. So it is effective. You are the effective power of attorney. There may be some limitations that are part of it, but ultimately the power of attorney itself is good. There could be some little things in there, but we could not necessarily figure out, and we could figure out in the right fact pattern, but ultimately you are power of attorney in Florida with an out-of-state power of attorney.
There is some questions over here.
Wait for the mic, please.
Ready? Are you ready? No? Yes. Okay, I have two questions. Durable power of attorney. As soon as it's signed, do you need to make copies for the banks? Anything financial, they need to have copies of that. Is that correct?
Basically, the power of attorney in making the power of attorney effective is the power of attorney. The attorney, in fact, has to go to the financial institutions to register the power of attorney. So if mom feels comfortable at that time, then the reality is it's best for mom and the attorney, in fact, to go to the bank and register the power of attorney at that point.
So the person that's the person that's giving what I want to say, the person that's being cared for, they actually need to go to the bank and register the power of attorney.
The answer is
not the person who is actually the durable power of attorney.
Basically, it's difficult. Banks hate powers of attorney. Banks hate powers of attorney. So I'll give you a specific example. I became power of attorney for a lady who lived in an assisted living facility. She was not doing well physically at all. And I go down to the bank down the street, SunTrust. I walk in the door and they say, "Rep, it's great to see you. It's been a long time." I personally know the banker who's helping me out. I personally know her. And we fill out the form card for the bank to add me as the power of attorney as a signer on the account. And the banker says, "Now we need to get mom's signature on the form in order for you to be the power of attorney." So what happens is this: the banks always want to get mom's signature. They don't need that, but it's ultimately, because it's so difficult at the bank, we generally would encourage mom, if she's capable, to go down there. If not, you just have to have an argument with them. Sometimes you do, sometimes you don't. But there is no legal reason that mom needs to sign that signature card. But sometimes, to get it done with, if mom is able to do it, then it's a fine way to go. So it's not legally, but ultimately banks are just difficult to deal with. So if you can do things and bring mom down there and it's not that much of a hassle, then it's okay to do. What we'd also say is this, is when you're doing that, you're generally not adding someone as a co-owner on the account. That can mess up mom's estate plan. You talk with the estate planning attorney about it. So you're not trying to add someone as a co-owner of the account, you're trying to add someone as the power of attorney.
So you don't have to have the person who's in power of attorney, their name doesn't need to be on the account.
That's right. They just need to register their power of attorney itself, which is a joy. Good question. I've raised like 80 other questions. We only have time for one last question, people.
If you had a power of attorney drawn up before 2011 because of changes, do you have to have it redone, or is it still?
Oh, that's a great question. So what we'd say is this, is powers of attorney generally should be updated every once in a while. And I can truly say this, so if you had a pre-2011 power of attorney, the power of attorney itself is good, right? So the law said anything before 2011 is just fine. But what we know is this, and this is from a personal experience, but it's also just from, there are trends in the legal world. And when I first started practicing law, and I've been part of my father's law practice for 18 years. When I first started taking over the practice, the powers of attorney we did were very plain, and it was the power to buy, sell, trade. But it did not include the power to do Medicaid asset protection powers, for instance. So those were not standard clauses that we put into our powers of attorney. So what we would say is this is probably a pre-2011 power of attorney should be updated. And generally, you probably update your power of attorney every 10 years, from a ballpark figure, every 5 to 10 years. So because these documents are so very, very important and so very helpful in the right situation, it's just a good idea to update them every once in a while. And thank you all very, very much. Thank you.
I'm sorry we couldn't get to all your questions. Maybe Rep will stay through the first break for individual questions. And now to Maria for our next speaker.
Isn't that great information from Rep? He has his table right over here on this side. She's waving her hand. If you have any questions or anything, come over and speak with him directly.